Jack Benny.
So now, ladies and gentlemen, we bring you a man who hasn't made a picture in over a year and still thinks he's a movie star, Jack Benny.
Welcome, everybody.
Hello again. This is Jack Benny talking. And, Don, I don't know what brought the subject up, but it might interest you to know that you don't have to make a picture every 5 minutes to be considered a movie star.
Well, Jack, I didn't mean that.
You know, after all, Adolf Zucker, the head of Paramount, gave me a 4-year contract. And Mr. Zucker certainly knows his onions.
He certainly signs them up, too.
Mary, you don't come in till the next page.
Oh.
All right, thank you, everybody, for sticking with me on that one. Jello, again, this is Ben Hitchcock Cross talking to you today. What I loved about that last section, and boy, do I got more to talk about, but what I loved about that last section is how it was all a build-up for Mary Livingston to say, oh. It's one of the greatest writing teams ever assembled, at least for the English language that I'm aware of. How's that for a caveat? Okay. Well, I am back. Hopefully this is the weekend, beginning of February of 2023 here. I am sort of just back from recovery from this month-long, I'd say, workplace bullying event with John C. Gelhard here. That's the hearing examiner for the Department of Workforce Development, overseeing at least 2 cases that I have. And most notably, he, when, let's say, yours truly stood up for the concept of, hey, let's not privilege Christmas over other holidays, say, for example, Hanukkah, that judge then told everybody, thank you for sharing that with us, that you're Jewish. And, you know, I think the main thing in the fallacy, I think that comes up from that statement there, that it's clear why this is so problematic is that this is somebody who is tasked and trusted by the state of Wisconsin to enforce the equal rights laws. And whether that's a good system or not, we'll leave that to you, but he is entrusted. And it's clear from his reasoning here that he believes that the only people who would stand up for Hanukkah are those people who are Jewish. And that's extremely problematic because one of the things that he's tasked with is to identify when people have stood up for the Fair Employment Act of Wisconsin. So, for example, it is unlawful for an employer to discriminate against somebody because they have stood up for the act. So let's just say you're an attorney working for the Department of Corrections, okay? And you're tasked with opposing another person who's, making a claim against the Department of Corrections. And during all that, the putative judge, the hearing examiner, says, thank you for, and it first of all identifies the holiday preferences of his boss, and then when the opposing counsel objects, he then says, thank you for sharing with us that you're Jewish. Okay. That person there who works, the other person who works for the state. So in this conversation, there was at least 2 sides. One of it's just the state of Wisconsin acting as the Equal Rights Division. The other is the state of Wisconsin acting as the Department of Corrections, okay? Both of those people are under a duty to not engage in workplace bullying and to report that. So that's they have that obligation. So the ALJ should have reported himself, and the somebody working for the Department of Corrections, anybody, paralegal, attorney, non-attorney, whatever, the state of Wisconsin has a policy that prohibits workplace bullying, okay? And so does that mean that I necessarily have to be, because I'm not an employee of the state of Wisconsin, that it's okay for them to bully me? Well, that's another subject. But it's, in my opinion, even to have been in a party of that conversation, that any state employee had the positive duty to say that that comment, Judge, is completely unacceptable. And not only for the reasons that I've cited, but just straight out bullying, because it was clearly meant as an intimidation to me. And it's sort of, kindergarten, well, let's say fifth grader-ish, sort of in that range, fourth, fifth grade there. Thank you for sharing. It's somebody who's got enough knowledge that they can't just straight out insult you. But they want it to be clear, in my opinion, that they are insulting you and calling you out, but sort of giving themselves some cover for that. And I note that whenever the ALJ or John Gelhard responds on that issue, he never says what he said. He just tries to say what I said, that I was the one who made comments about religion. So therefore, whatever he says is okay. That so far has been the sum total of that justification there. Okay, I'm still a little bit shaken up from it. That's how it goes. I wanted this to not be this sort of pre-segment here, not to be a self-indulgent pity party here, so much as to say that I do feel that I have had some slight insight into what workplace bullying is. Now, my workplace is rather privileged, and for a lot of different reasons, I'm rather privileged in that workplace. So I got to acknowledge all that. But still, I have to come to work every day. And this is why workplace bullying is so pernicious and so needs to be eradicated totally, is for this reason. We come to work to do a job, and we do that job to take care of ourselves and our families. And that's part of the whole, promise of the system there, is that you're going to work. And that you're not doing this necessarily voluntarily because you want to, because it's that great, or that you really have a choice in the matter. And realistically speaking, not just as an attorney, but as an employee, I don't have a choice in the matter to say I don't want to deal with this judge. I just don't. So, I can make complaints, I can do whatever, but it's to the extent that I do that too, it's also going to take away from my other clients, my other responsibilities, my other duties, and it's going to go make my month more difficult. So many people, I imagine, would, and especially based on the behavior of this judge, have just said, fine, I am going to let him get what he wants. Now, we may have done that, if I can conjugate that verb so boldly. But the point is, again, the fact that the secretary of the Department of Workforce Development is the boss of the judge, in my opinion, made that impossible. So, that is the second point, and the judge then again doubled down on that after everything else that's happened, and I'm sure there'll be plenty of content for that. Oh God, I did it again. Here we are. Sorry. Self-indulgence time here, and now you get to look at my face and bearing the lead and all the rest. But bad video, we're not going to go back on that, and I hope you all forgive me. Thanks so much for joining me, by the way. Man, this is a ramble fest here. But here again, the judge put into writing that if we really believed that there was a conflict of interest, we would unilaterally withdraw our Wisconsin Fair Employment claims out of the Equal Rights Division and go to the EEOC, the federal. Okay, and leaving aside the fact that the Wisconsin law and the federal law are totally different, and that the remedies in the Wisconsin law are different than the federal. They're not totally different, but they're different. Okay? just leaving all that aside, that not once, I think even 3 times, this judge has put in writing that it is on the employee to remove themselves if they think that the ALJ is conflicted. And then, moreover, the judge finds that because we have not gone to the EEOC, we must really not believe that there's a conflict of interest. And therefore, he feels entitled to find that there's not a conflict of interest. No, I think more importantly, he's entitled to find that we have admitted that there's no conflict of interest. Okay. So I really think that both of those statements in and of themselves, and there's certainly more there, but both of those things are beyond the pale, and I do think that the state of Wisconsin needs to take some kind of action in response to that to prevent those kind of actions ever happening again. Certainly, thank you for telling everybody that you're Jewish. I don't think it takes a rocket scientist to understand that this is problematic and why this is problematic. I can tell you that his supervisor knew about that within a week, and that was right before Christmas. So here we are a month later, and nothing's happened. That's his supervisor, by the way, is Maria Selsor. And part of the issue there is Maria Selsor is his peer. She's also an ALJ and had been an ALJ for a long time, and now is also his supervisor. Again, the appointing authority, the person with the power to actually discipline this judge, will take no action because she says, according to policy, this has to be referred to her by the supervisor. So I think we've, at least with this issue here, we have been able to move the needle forward in terms of what the problem is and why no action is taken. We're just going to shift totally and deal with this issue, and then we'll get on to what I had up there on the screen for the whole time. Sorry, guys. Okay, that's going to be great. And please stick with us on that one because it's going to be great. So, yeah, I don't even know what the headline for that could possibly be. Yeah, is there like a word for trampling and using something as toilet paper simultaneously? Anybody got an idea for that? Let me know. So finally, just back to this concept here, the Ramona Natera, the division administrator, knows all about this issue. Other ALJs have had to report this to them. Let's see, does anybody, Heidi Marshall knows about this. There really isn't a person at the Department of Workforce Development, I'm sure I've mentioned this to the receptionist, that I haven't talked to because I think it's so shocking that it's what's shocking here isn't that he said these things out loud. It's that he feels that absolutely free to say these things and put them in writing, not once, not twice, but 3 times. One loves to say thrice, but one shouldn't. And that no consequences have flown from that. And because I cannot tell you that if this was a Department of Corrections officer or sergeant, even a warden, they would be on leave and possibly and under disciplinary investigation since Christmas. And, I don't think it's appropriate to treat attorneys who are working for the governor of the state of Wisconsin as if they were Supreme Court justices with lifetime tenure. Because it's not. It's also not fair to treat them as though they are elected judges who can face the voters every so many years to get reelected, because they're not. So some mechanism needs to be in place here to deal with these kind of actions, and the state of Wisconsin seems to uniformly refuse to do that. And I'm sorry, I don't want to say the state of Wisconsin, because I think there's other avenues. The state of Wisconsin has many arms here, and I think there's other avenues that can and will be, turned to for this, not the least of which is Democratic criticism here and Democratic scrutiny. For example, the legislature should be involved in dealing with this issue here. Absolutely. I mean, this is a systematic problem that should not ever happen again and needs to be brought to everybody's attention. And I think that not only the ERD needs scrutiny from various branches of government, but this situation does. And again, I'm not necessarily saying that this decision, anything in this case, needs to change or be changed by anybody. But the fact that a judge can say, thank you to opposing counsel for sharing with us that you're Jewish, and then to also direct the opposing counsel to withdraw somebody's complaint. No, let's put it another way. Saying, unless you withdraw this complaint, you don't really feel that there is a conflict of interest, so I'm just going to go ahead and rule against you. I think that may be a more accurate way to put it there. And then to say, because you didn't withdraw this case to the ERD, you don't really feel that there is a conflict of interest. And again, the fallacy in that is there's two things in there. Again, the Wisconsin Fair Employment Act is different than the federal law. So you would be giving up all of your Wisconsin Fair Employment Act claims. That's one thing. So why would you do that? That's because he says it's common sense. That's the word that he uses. It's common sense that if you really thought that there was a conflict of interest, you would remove it. Well, okay. So I don't think that's common sense by any stretch of the imagination that somebody would go against their interest. But then I think what's more common sense, and we've talked about this before, is that you would expect a judge to do their job. And you would expect that if there was a problem, they might follow the statute that was already there in place to address what a conflict could be and how it should be dealt with and how they can get other hearing examiners from other departments to hear that aren't have their paycheck signed by Amy Petchek, for example. We had suggested that, I think 8, 9, 10 months ago, directly to Amy Petchek, and their response was to no response. So it's not like there isn't the will of the legislature isn't already clear. It's just that the ERD doesn't feel like it has to follow those common sense rules and the law. It's not just because we don't do it just because it's common sense. We do it because it's the will of the people of the state of Wisconsin. The policy. So that, I think, again, and I know I may have touched on so many of these issues before. Thanks for sticking with me here. But when he reframes it in just those words, I think it's really easy to tell. And now, because I have spoken with Ramona Natera, and she has said that she's not receiving any of these complaints, the key word, receiving complaints, that means you may send me 100 emails that give me every bit of information about them, and it may be required in several handbooks that I take action just based on the knowledge here. But because it says in other handbooks that I don't act on discipline until I hear from the supervisor, then I'm going to follow that rule. That's sort of what receive means there. Which, we've heard that from Matt Chasen. We've heard that in many other situations in terms of public records. We've heard that. I'm sorry, in terms of complaints by public employees. So that's why we all need to be on the watch for that word. Received means I'm acknowledging that I actually have to do something with that. Otherwise, if I'm like Matt Chasen, for example, he sometimes receives things, but he receives them from informational purposes. So unless you straight up ask him how it is, he might not tell you. So MPS people, unless you straight up ask Matt Chasen how he's taking in this information, you may never know. Okay? So that's important concept to get there. And now we have followed up with Maria Selsor. And another thing I would advise everybody to check out is, we got basically a non-answer. So then we made a simultaneous public records request and said, hey, I want all of the records related to all of your handling of all the complaints. Because I've personally made several. I want all of the complaints that you've received. And then I want separately all of the documents that evidence how you've handled them. For starters. So we've got the systematic issue here, systemic issue that needs to be addressed is if an administrative law judge commits misconduct, is there any way to have that dealt with on a disciplinary level, right? Because the alternative is to wait 8, 10, 12, 15 months to go to review the decisions on the abuse of discretion standard at LERC, wait another 3, 4 months, 10, 20 months for LERC to make a decision, have another hearing again a year and a half, 2 years later, possibly with the same ALJ, you don't know. Possibly not, possibly nothing. That is not an acceptable way to deal with these issues here, especially the ones that cross the line into workplace bullying, as we've seen there. It's just unacceptable. And the state of Wisconsin, particularly Tony Evers, has pledged to do better. And they certainly have enforced these kind of rules on low-level employees all day, every day. All day, every day. I know because I hear about them, and I'm sure you all know about it too. So, and again, this is a judge, this is John C. Gellhardt, who has no problem dismissing cases when you violate the rules. But if he violates the rules, there's a different sort of standard there. And I think that that's another big problem, too, that we're going to get into, but we'll save that for another time. All right. I'm frustrated here, but we can do better. The state of Wisconsin needs to do better. Stick with us. We'll keep you informed.